Okay, this is the Makeup podcast I promised you guys from us missing class back on Wednesday, January 16th. And if you recall, we got through problem 3.1 on page 46, and we just started talking about our first building block, which was discharge. So we're going to, here in just a second, pick right up with problem 3.2 on page 46. But first, just quickly, what did we do last time? We looked, of course, at collecting the backdrop of the fact that collecting debts while outside bankruptcy is challenging. Debtors have limited assets. There's competing claims. I don't know that I mentioned potential fraudulent transfers. That's a thing that we'll worry about a little bit later. But I think the big thing was these first two, limited assets and competing claims. And so there's this race to the courthouse. If everyone, it's every man for himself. So the good thing about bankruptcy is that it allows there to be this collective collection process where everyone kind of shares alike, and no one has to duplicate efforts. So we went next to the overview of bankruptcy goals of debtors, creditors, and other constituents, and our twin aims of bankruptcy law are both equal treatment of creditors, and then also, of course, from the debtor's perspective, the debtor wants a fresh start, a rehabilitation, kind of getting out from under personal liability of debt. Looked briefly at some constitutional considerations. The Bankruptcy Code is actually authorized congressionally to impair contract rights of creditors. In other words, creditors think they're owed $1,000, but they may only get $100 out of bankruptcy, and that's going to be okay. But the Bankruptcy Code is actually not authorized to take property rights without just compensation, so that has its roots in the Fifth Amendment. And the Due Process Clause, and so we're going to see that is implicated and vindicated throughout the Bankruptcy Code as well. We looked at structure of code and major players, just kind of defined what the various chapters of the code are, and the debtors and creditors and trustees. And so we'll kind of come to that from time to time. But for now, just by way of overview. And then finally, we said we're going to start our semester with some basic building blocks. Some of these we're going to come back to and drill deeper. But just to start with just some basic building blocks, and the first one of which is the concept of discharge. That is the idea that when a debtor files bankruptcy, they eliminate liability on debt. And that's called discharge in the code, section 524. So I'm going to pull that back up here in just a second. But basically, we saw that the discharge it's effective, but it's limited in scope. So it only eliminates the personal liability of debtor. And notice there's kind of two aspects. It's only the personal liability of debtor, and then it's only the liability of debtor as opposed to third parties. So we'll see that in just a moment, played out more in the problem, starting with 3.2. We also saw from the educational student loan case that not all debts are discharged. So there's a list of exceptions in 523 that we're going to come back to, certain public policy-oriented exceptions. There's also, I don't think we mentioned this, but there's timing issues. Only debts that came before you filed bankruptcy generally are discharged. Post-bankruptcy debts are generally not going to be discharged. We'll kind of come back to that later. I don't know that we saw this yet. There's limits. You only get Chapter 7 discharge every 8 years, so I'm kind of doing a quote review before we've really looked at it. And then we're going to see in a moment 525, anti-discrimination. And then finally, we're going to mention equality of distribution. That is a building block, although we're not going to really see a whole lot of problems on that for now. So that's sort of the review, plus at the end, this building blocks, we still had some more problems to do. So let's go to those now, if you'll bear with me a moment while I switch. So as I pull up class unit 1, bear with me as this pulls up, and then we'll scroll down to problem 3.2, which is where we left off, and that will be here. So let's pull this up and see what we got. So problem 3.2, and you always want to pay attention, by the way, with our Epstein text to the title. The title pretty much tells you very straightforwardly what concept they're trying to illustrate. So here, problem 3.2, discharge and what a secured creditor can do. Remember, secured creditors are prohibited from doing things once there's a discharge. And so we saw last time in problem 3.1, they're prohibited from taking any action or suing. Now let's see what else secured creditors are allowed to do versus are not allowed to do. So problem 3.2, this is on page 46. It says D owes S $20,000. The debt is secured by a lien on D's truck. D files a Chapter 7 petition, claims the truck is exempt, receives a discharge, and then retains the truck. Here's the question. Can S still repossess the truck if all it does is repossess and sell according to state law and does not threaten to pursue D for any deficiency between the $20,000 owed and the net proceeds of the sale? In other words, we're just getting the truck, not any debt. We're not collecting Benjamins. We're only getting the physical truck. Well, remember from last time, what does 524 say? It says a discharge in a case, and this title, number 1, voids any judgment. So we're not really worried about that here, or any act. But look at number 2. It operates as an injunction against the commencement or continuation of an action. So you would think getting the truck is an action, repossessing the truck is an action, but what actions? Actions, employments of process, or acts to do what? Collect, recover, offset debt as a personal liability of the debtor. Well, personal liability means we're seeking to collect money, make him write a check. Here, though, we got the truck, and that's not personal. That's property, right? That's in rem versus in personam. And so the short answer is that the discharge does not prevent S from repossessing the truck, because that's not collecting on a debt. I know that may seem sort of like it, but it's different. It's there's 2 parts to a secured debt. There's the debt part where you're supposed to pay money, and there's the property part, the lien, where they can repossess the item, the truck, the car. And the discharge does not eliminate their right to take stuff like repossessing trucks. It only eliminates the debt, again, as a personal liability of the debtor. So answer here, no problem to take the truck, right? No problem to take the truck. Okay, let's look at problem 3.3, discharge and what a creditor can do to third parties. So it says DOC $30,000. The debt is guaranteed by G, that stands for guarantor. D files Chapter 7 petition. It says C receives $3,000, 10 cents on the dollar from the Chapter 7 trustee, and D gets a discharge. So from D's perspective, wow, I owed $30,000, now I only had to pay $3,000, I got to get rid of $27,000 in debt. Well, can C sue G for that other $27,000? In other words, does the discharge let G off the hook? And the answer, of course, is no. The discharge of 524 is only an elimination of the personal liability of the debtor. G is not a debtor, right? He is a third party. In fact, E, we almost didn't need E, but E clarifies that discharge of the debt of the debtor does not affect the liability of any other entity or the property of any other entity for such debt. So it only gives the debtor discharge. It does not give anyone else like G a guarantor. So short answer, can C sue G? The answer is yes, right? Because G is a third party and does not get the benefit of the discharge. Well, let's look at part 2. By the way, exact same problem, just slightly different facts. Now, C has a $1 million malpractice judgment against Dr. D, and Dr. D files bankruptcy, again, gets a discharge. Applicable law, though, permits injured victims to sue insurance companies directly. So in other words, hey, insurance company, you insured against Dr. D's malpractice. I'm making a claim on that policy. Can C recover from Dr. D's malpractice insurer? And what's the answer? Yes, right? Again, the discharge only eliminated Dr. D's personal liability. It does not affect liability of any other entities, like here, insurance companies, right? So you can still go after insurance company, and of course that is often the type of thing that it does happen in bankruptcies when the debtor files for bankruptcy and receives a discharge. Okay, next up. So, problem 3.4, discharge and what the debtor can do. Diaz, various credit card issuers, 40 grand, files Chapter 7, gets a discharge. Creditors get nothing. It's a so-called no asset case, so not even 5 cents on the dollar, it's 0 cents. Question, can D still voluntarily pay the credit card debts? And it tells you to see 524F, and guess what that says? Yes, right? We can. Nothing contained in this section prevents a debtor from voluntarily repaying the debt. I don't know why you would. You may not be advised to. Maybe there'd be some reason why you might want to pay a particular creditor. But in the bankruptcy code is clear. If you want to do it, we're not going to stop you. It's just that the creditors cannot pursue. Well, and here's the query. Can you think of any reasons why debtor would want to do this? I think typically, say if you have some merchant that you want to keep doing business with and you want to keep that relationship, you might simply want to pay them so they'll keep seeing you, whether it's a dentist or a contractor or whatever it is. But you do that on your own time and on your own decision. Okay, problem 3.5. Discharge and the single debtor. That's a bit of a misnomer. This question isn't really directly about singleness or marriedness. It's really about how often can you file bankruptcy. So notice it's Rupert and Mary Barra file a joint petition under Chapter 5, and notice it was 5 years ago. That's going to be a key fact. Spoiler alert. Okay, they got a discharge 5 years ago when they filed 7. Last year, Rupert supposedly went out for bagels one Sunday morning and said ran off for good with his new secretary. Lovely. Mary, who was left with 5 minor children, one of whom has a congenital heart problem, no health insurance, and a mountain of joint debts, mostly run it by Rupert, has now decided that despite working 2 jobs, there's just no way she's ever going to get out of the hole. Therefore, blah, blah, blah. But what does she want to do? She wants to file Chapter 7 again. What do you tell Mary? Well, it tells you to see 727A. And what does that tell us? The court shall grant the debtor a discharge. So this would be in a Chapter 7 case. 727 is the Chapter 7 discharge provision. Court shall grant debtor a discharge in a Chapter 7 bankruptcy unless what? Number 1, actually, the debtor is a corporation. We don't give corporations Chapter 7 discharges. But skip to number 8. The court shall grant the debtor a discharge unless what? Unless the debtor has already been granted a discharge under this section in a case commenced within 8 years before the date of filing. Well, it's only been 5 years, right? And so, she cannot file Chapter 7 yet. She's got to wait 3 more years. We'll talk about this a little bit later when we drill down further in discharge. It may turn out to be that she could file another chapter, like probably Chapter 13. But Chapter 7, the code only allows you to file them every 8 years. The idea is we don't want you filing every 6 months, racking up debt, filing again and again and again. You got to at least wait 8 years, just as a matter of fairness to the creditors. Okay, so she's got to wait. That's the short answer. So next up is discharge and what governmental entities can do. And this is kind of a sly way of telling you about Section 525, which has 2 parts. Let's read the problem first to set it up, and then we'll talk about 525. But spoiler alert, 525 is supposedly, and it is, about the extent to which, or rather the fact that you're not supposed to be able to discriminate against someone when they file bankruptcy. In other words, just because they filed bankruptcy, you're not supposed to be able to treat them differently or treat them negatively. And that's sort of true. It's on the books. It's 525, but let's see how much protection it really gives. So first, 525A is about what governmental units are prevented, and then we'll see subsection B is about what private entities. So first, 525A, governmental units. Let's read the problem. State S requires licensing of operators of so-called driver training schools. And it says D has such a license and operates a driver training school. D has consulted your firm about his filing for bankruptcy to discharge debts, most of which arose from D's operation of his driver training school. If D files for bankruptcy and receives a discharge, can State S revoke D's license? Okay, now, and it says see Section 525A. Okay, so here it is. Now, 525A only applies to governmental units. It says a governmental unit may not what? May not do some stuff. May not deny, revoke, suspend, or refuse to renew a license, other stuff, permit, charter, franchise, or other similar grant to, condition such a grant to, or discriminate with respect to such a grant against. So in other words, among other things, governmental units may not revoke licenses. Now it also says, or discriminate with respect to employment. By the way, I skipped. They may not deny employment to, terminate the employment of, or discriminate with respect to employment against a person that is or has been a debtor under this title. In other words, filed bankruptcy, or another person with whom such debtor has been associated, solely because such debtor is or has been a debtor in this title, has been insolvent, or during the case before the debtor is granted or denied a discharge. Or okay, so what's the long and short of this? Short version: governmental unit not allowed to revoke a license solely because someone's filed bankruptcy. Not allowed to do other things either, by the way. Not allowed to deny employment to someone solely because they filed bankruptcy. Not allowed to fire someone solely because they filed bankruptcy. Not allowed to discriminate against someone with respect to employment solely because they filed bankruptcy. Here, though, the applicable restriction is they may not revoke a license solely because they filed bankruptcy. So the short answer would seem in problem 3.6 to be no, the government can't do it. Now, query, what is the word in this statute that gives state S the most wiggle room? And of course, it's the word solely. You may not revoke the license solely because debtor has been a bankrupt debtor. So what does that raise? If the state can think of other genuine reasons, now it can't be a pretext, right? But if there's genuine other reasons, like maybe there's been too many complaints against D's driver training school, so that's an independent reason. That's why he owes so much money. Maybe state has a policy of all schools are required to refund unused tuition, and the D's driver training school has not been doing that. So as long as the government can come up with some reason in addition to the bankruptcy or instead of, then 525A is not much solace, but it's at least something. And if it's shown that the non-bankruptcy rate reasons are a pretext, then of course they will be in trouble, and this would be actionable. But here, as long as they find other reasons, it's okay. But they just can't do it solely because of bankruptcy. Now let's contrast in 3.6 to 3.7 between what 525 says that a private, non-governmental employee can do. So let's set up the facts. D files for bankruptcy, receives a discharge. D applies for a job with your client, T Trust Company. Okay, so we're not a government entity. We're just like a bank. As a cashier. T wants to know if he can tell D that T has decided to hire someone else other than D because of D's bankruptcy. In other words, dude filed bankruptcy. We don't want to hire him. Can we just say that's the reason? Well, it says see section 525B and consider the next case, Burnett versus Stewart title. So we already look at 525A. Look at 525. This should say B here. No private employer may do what? Terminate the employment of or discriminate with respect to employment against an individual, again, solely because he's filed bankruptcy. Now, if you looked at the Burnett case on page 48, which the problem prompted you to do, it did a little bit of statutory construction between 525A and B and said something about whether denying employment. Because remember, the facts are we're not asking him to fire someone. We're just wanting to not hire him in the first place. We want to deny him employment initially. Well, Burnett looked at the statute and said, you know what? Up here in 525A, Congress specifically said that governmental units may not deny employment, right? They said other things as well, may also not terminate, may not discriminate. But down here in 525B, it doesn't say may not deny employment. It says may not terminate. If you've already hired him, you can't fire him for filing bankruptcy. And if you've already hired him, you can't then discriminate with respect to employment. So you can't, deny him a raise or promote someone over them solely because of the bankruptcy. But you know what? 525B pretty clearly was held not to prevent a private employer from denying employment in the first place, simply because that prohibition, although present in A, with respect to government units was not present in subsection B with respect to private employers. So the answer is we can tell them all day long, sorry, dude, we're not hiring you because you filed bankruptcy. Okay, and that's pretty clear protection. So not much protection for individuals as far as trying to get a job. Now, once they're on the job, then we do have the protections. You're not supposed to be able to fire them, terminate them, or discriminate. There again, though, remember the word solely. If the private employer can think of another reason, bad work performance, things of that nature. Maybe he'd already been hired as a cashier, but he's filed bankruptcy, and the customers are starting to leave the bank because they don't trust a bank that has a bankrupt cashier. I don't know. Maybe that could be true. Then they could probably come up with other reasons. So the truth is that it's not a ton of protection, given that the word solely exists in both subsections, but it's at least something. It's at least something. Okay, so for my last slide for the first unit was just reiterating equality of distribution. And as the quote here says at the end, for this bankruptcy system to work, for collective liquidation, similarly positioned creditors are required to be treated with substantial equality. In other words, we want to have them buy in that they don't need to all go race to the courthouse, and their comfort that they can rest assured in the system is that they'll be treated fairly. Now, the second bullet says some creditors are more equal than others. And, that sounds more ominous than it is. Some creditors are entitled to better treatment, and we'll see why when we talk about that a little more detail. Okay, so that's it for the Unit 1 syllabus. Let me pull up Syllabus Unit 2, and we'll just continue right along. So pull up Class 2. We've already done this review slide, so I'm going to go right to our next building block, which is the concept of property of the estate. Property of the estate. So this is discussed in your book beginning on page 52. So we're going to talk about this next. As your text talks about on page 52 to 53, there's some reasons why property of estate is an important concept. By the way, I think I've mentioned what is property of the estate. The idea is it's when you file bankruptcy, it creates an estate. Just like when you die, you create an estate. That's usually what we think of when we hear the word estate. The idea is you died, physically died, and so now we administer your assets through an estate. Well, when you file bankruptcy, the idea is you kind of financially die. It's a bit dramatic, but that's the idea is, okay, it's like administering your financial estate once you die. I guess that's the idea. So why is this an important concept? Why does it set up this way? Well, the code uses property of the estate in several ways. First and foremost, Chapter 7, the concept of liquidation is that debtor completely surrenders all of the property of the estate, and that's what's distributed to creditors. That is, by definition, what we mean by bankruptcy liquidation. You're liquidating the property of the estate. In a Chapter 13:11, given that Chapter 7 liquidation is a baseline, Chapter 13 and Chapter 11 are reorganization chapters, which you remember let you keep your property of the estate. Nevertheless, though, in order to confirm a plan under those chapters for paying income over future years, those chapters require that the debtor pay the unsecured creditors at minimum at least what they would get already in a Chapter 7 liquidation. And that turns out to be the value of the property of the estate. So the idea is in those reorganization chapters, hey, we're not going to waste everyone's time for several years of payments unless it at least equals at a minimum liquidation value, which turns out to be what they could get right here, right now, if we just sold all your property of the estate. So it becomes an important benchmark even in non-liquidation cases. And then, as we'll see, many other bankruptcy provisions refer to property of the estate as a concept as well. So we'll see that as we go. Questions to ask. I think at the bottom of page 54, the book says, ask these questions as you're making your determination of what is property of the estate. And we're about to see our definition in a minute in section 541. But in general, these are the questions you're going to want to ask as you look at property of the estate. The first question, of course, is the item in question property at all, right? Is it property? Because it can't be property of the estate unless it's property to begin with. So that'll be the first question. Number two question, assuming it is property, then what is the debtor's interest in that property? That's important. So just because, I hate to ruin the surprise for some of the problems here in a second, but just because Blackacre is property doesn't mean 100% title to Blackacre is property of the estate, because debtor may not own 100% of the interest in Blackacre. So we got to ask, what is debtor's interest in that property? Because, as we're about to see, Section 541A1 merely reaches the debtor's, quote, interest in property rather than simply the property. Number three question to ask is, did the debtor have this interest in the property as of the time of commencement of the case, the bankruptcy case? In other words, you got to take a snapshot. So, here's the timeline, and then bankruptcy is filed here. We got to ask, did we own the property as of the moment of bankruptcy, right? We may have sold it before then. If so, it's no longer property of the estate. Maybe we didn't come to acquire it till later. If so, it wasn't property of the estate as of the moment of bankruptcy. So you have to kind of take a snapshot. Although we'll add some caveats to that here in a second. But that's the initial baseline determination, is did debtor have the interest in the property as of the time of commencement of the bankruptcy case? Okay, so let's actually take a look at Section 541, which defines property of the estate, and it, I believe, is in your text on page 54 and 55. And so what does 541 say, at least the relevant parts that we care about? So 541A says the commencement of a case under this title creates an estate. In other words, whenever you file bankruptcy, it creates an estate. Such estate is comprised of all of the following property. So all property of the estate is property. All the following property, notice, wherever located and by whomever held. So normally debtor has it, but as we're going to see, maybe you loaned your saxophone to someone else, and just because you loaned it to someone else doesn't mean that's not property of the estate. So all the following property, wherever located and by whomever held. Now, subsection A1 is the broadest it could possibly be. So it does have a little carve out, except as provided in subsections B and C2, which we won't worry about right now. Notice the main operative provision. All legal or equitable interest of the debtor in property as of the commencement of the case. So that's as broad as it could possibly be. Any legal interest in property, any equitable interest in property, both are considered property of the estate as long as you had them, again, as of the commencement of the case, as of that snapshot. Now, there's several subsections. If you read 541A, there's 1 through at least 6, and it may go beyond that. But let's just focus on subsection 6 to add to this concept for the moment. So in addition to what we just said, all legal or equitable interests that we have as of the snapshot, as of the commencement of the case, we also add subsection 6, all proceeds, product, offsprings, rents, or profits of or from property of the estate. Now let's stop there. So again, here's the timeline. So we look at the snapshot. Do we own the property as of here? Now, again, I hate to ruin a problem, but if we have, let's say property item A that we do own as a property of the estate, and then somehow property item A generates proceeds, or let's say we sell property item A here, or property item A somehow generates income here. Now, you would see these dollar signs coming post-bankruptcy, right? And you might say at first, oh, well, that's after bankruptcy, so it didn't count. But what 541A6 is saying is, if to the extent these monies or items are derived from property that was property of the estate, their earnings from it, or rents from it, or profits from it, then those also are included because they relate back to property that was property of the estate as of the commencement of the case. Now, there is one big exception, except we don't include post-bankruptcy petition amounts that are earnings from services performed by an individual after the commencement of the case. So basically, your salary, if you work a job and then you get money after bankruptcy is filed, that does not count, right? So only proceeds or rents or profits from your property, but not to the extent it's just your basic individual earnings. That is excluded. The idea is you get to keep that. In a Chapter 7, you only have to give up your property, but you don't have to give up your future earnings. You only do that if you file for Chapter 13 or Chapter 11. Okay, so now my drawing may cover, I'll have to get rid of this now. Look at this note for a second. 541A5 also includes life insurance and inheritances received within 180 days after bankruptcy. And so even though, bankruptcy is filed here, if you have an uncle that dies, here's the 180-day period. If you have an uncle that dies here and leaves you money, or, your spouse dies here and you get the life insurance, if that happens within 180 days, that comes back and is included within property of the estate. Notice it's within 180 days, so it's grim as it is, your creditors are rooting for your uncle to die during this period, because that means that's money for them. If you're rooting for your uncle to make it to day 182, because then you keep the money and it doesn't have to go into the estate for your creditors. So that's point 541A5. Another couple of points. Even though there's sort of this snapshot idea that only what you have as of bankruptcy filing, if you do file Chapter 13 or Chapter 11, property of the estate actually continues running through the entire case. So there is no, and it includes earnings. So the idea in those cases is you're going to be contributing your future income anyway. And so the kind of snapshot idea is not as critical for purposes of property of the estate. So if it's Chapter 13 or Chapter 11 and you're an individual, even your paychecks post bankruptcy are considered property of the estate. So that's a difference depending on what chapter you file. All right, so what is next? Some problems, I imagine. Let's do some problems on this concept of property of the estate. And the first one will be problem 3.8 on page 55. So it's got several parts. Let's do 1 through 4. Number 1, D is paid every Friday. D files a bankruptcy petition on Friday, April 1st. Is the paycheck that she receives on April 8th property of the estate? Well, no, right? What did we just say? It's a snapshot, and A6 says no earnings from services by an individual after the case. April 8th is after we filed on April 1. So as long as we filed Chapter 7, no. Now, I suppose if we filed Chapter 13, then yes, they would be, right, for that provision we just saw. But assuming we filed Chapter 7, then no. Your post-bankruptcy earnings will not be property of the estate. And then there's the Chapter 13 provision I just alluded to, which would bring them into property of the estate. Okay, in fact, if you read that in Chapter 13, 1306, property of the estate includes earnings from services performed by the debtor after the commencement of the case. So it's completely the opposite if you file Chapter 13. So we would need to know what chapter. But in a Chapter 7, no. Post-bankruptcy earnings for personal services would not be property of the estate. Okay, how about number 2? D owns a rental house, and she files a Chapter 7 petition on September 30th. So that's the bankruptcy date. Is the October rent from the house property of the estate? Well, yes, because even though, here's bankruptcy, filed on September 30th. The house is owned here, but the rent comes here on October rent. Well, guess what? Even though this is post-bankruptcy, we know that rent from property of the estate is included, and so this would be property of the estate because it relates back to the house, which was property of the estate as of the filing of the case. All right, number 3, guess what? These are all kind of variants. Spoiler, the question's the same in all of them, these next couple, that the item is property of the estate. What's going on number 3? A&C Rental Corp files a Chapter 11 petition on November 13th, continues to rent cars and operate its business. Well, guess what? Once again, here's the bankruptcy date, November 13th. And so we keep renting cars. And so we have these cars that we owned as of property of the estate, and then we get rents from them after the case. Well, again, what's the operative rule in 541A6? Proceeds, product, offspring, rents, or profits from property of the estate are included And so, yes, these rents will be included per 541A6. Guess what? Exact same answer here. Number 4, Circuit City filed Chapter 11 on November 10th. Okay, so it says that we got various cash and credit card receipts post November 10th. Were those sales property of the estate? Well, guess what? As a practical matter, how did Circuit City get that cash on the credit cards? Well, they probably got it from selling their inventory of electronics that they owned as of the bankruptcy. And so the inventory was property of the estate, so almost always these cash or credit cards will have been proceeds or product or profits from property of the estate. So the same is true as the rent house and the rental cars before. And in fact, in a Chapter 11, because they had a bunch of property before and they keep selling it and pouring money back into the business, the question is, as of the commencement of the case, a significant limitation in a business Chapter 11 case? The answer is no, right? Because it's just like when American Airlines files, they have all their planes as a property of the estate, and they keep flying them, and they get airfares and all that, and so everything relates back. So all the income is going to be property of the estate and subject to the creditors when it's a business. And remember that we're talking about earnings from a business now. The exception in 541A6 was for earnings by an individual. That's a human. So Circuit City was not a human, right? ANC Rental Corp, not a human. And so that's only for individual humans and their paychecks, but not for businesses like Circuit City. Those are not excluded. They come in property of the estate. Oh, I forgot. There's one more question in 3.8. Number 5, how do you know what debtor's interest in property are? And it says see section 521. Well, guess what? You go read 521 and you find out, lo and behold, that whenever a debtor files bankruptcy, they're required to file various things, right? They're required to file schedules, list of creditors, schedule of assets and all your debts, also all your income and expenditures, and a thing called Statement of Financial Affairs. It just asks for all your major transactions, usually for the last couple of years. But the bottom line is you got it, debtors required to divulge all this information, and so then we scrutinize it. But that's how we know what property is. And there's kind of akin to a discovery process as well that happens so that we can clarify and make sure that all the property is listed. But that's how we know, is we have the debtor file schedules. Okay, next up is problem 3.9. Remember that 541 says that all legal or equitable interest. So let's take a look at what 3.9 is talking about. It says T tortiously enters P. P for plaintiff, I suppose. T for tortfeasor. P sues T for damages for her personal injuries. While the lawsuit is pending, P, in other words, the victim that has the tort cause of action, files for bankruptcy. Is the pending lawsuit property of the estate? That's really the question. Then they say, if so, so what? Should T care? Should P? P's creditors, P's personal injury attorney? Someone must care, right? And the answer is yes, someone cares. And in fact, it is property of the estate. Take a look. What does 541A1 say? Property of the estate is comprised of all property that includes what? All legal or equitable interests of the debtor in property. Guess what? Cause of action equals property. And so here, the lawsuit claim would clearly be property of the estate. By the way, as to why all these people care, should T care? He better care. He can still be sued, right? Even though he may think, oh, now he's filed bankruptcy. They're crippled, right? They're financially unable to. No, that's not true at all. We're still going to come after him. In fact, P should care because, his rights will be vindicated. P's creditors especially will care because they may get some money out of this, because remember, this money generated from the tort suit may well be property of the estate and will be available to them. P's personal injury attorney may get paid to bring the case to finalization, so he may get fees, and so all these people may care. But the short answer is cause of action is included in property. It's an asset that you own. Property of the estate is very, very broad. Okay, what is 310 about? interest of the debtor in property as a limitation. Okay, D and T each own an undivided 50% interest in Blackacre. D files for bankruptcy. Is Blackacre property of the estate? Be careful, you don't want to just say Blackacre in full is property of the estate. What do we have? D and T each own 50%. So when D files for bankruptcy, the 50% interest is property of the estate, but of course D's interest is not. And we can do that. Undivided 50% interest can be split up that way. And so only, you wouldn't say all of Blackacre was property of the estate. You would say D's undivided 50% interest in Blackacre was property of the estate. Because remember down here, property of the estate is all legal or equitable interest of the debtor in property, not just Blackacre, but interest of debtor in Blackacre. Okay. So whatever 50% of the value of Blackacre is, that would be property of the estate. Number 2, D is leasing Blackacre for 10 years. D files for bankruptcy. Is Blackacre property of the estate? Well, no, right? The fee simple absolute in Blackacre is not, but you know what is? The leasehold interest, right? D owns a leasehold interest. By the way, that can have a market value, but we would only say the leasehold interest in Blackacre is property of the estate. We wouldn't say the underlying title to Blackacre is. So again, it's always only the interest of the debtor in property, and here that interest is just a leasehold interest. Okay, next up, number 3. F loaned $100,000 to D to buy Blackacre and retained a mortgage on Blackacre as security. D later files for bankruptcy. Is Blackacre property of the estate? Well, again, does D have any interest in Blackacre? And the answer is yes. But again, what's the valuation of that interest? It's certainly not the full unencumbered value of Blackacre, right? Because there is this mortgage on it. So what you would say is, yes, Blackacre is property of the estate, but of course it's subject to a mortgage, and it's really only going to generally be whatever the equity is. So say that Blackacre is worth $120,000, okay, and the mortgage is $100,000. Well, guess what? It's only going to be, as an economic matter, it's only going to be that $20,000 in equity that is property of the estate, right? As a practical matter, since F has first dibs with a secured claim, of course, that's not available to that extent to all the creditors. So sometimes, and I think even our authors will sometimes say, oh, this isn't property of the estate, it's all earmarked for F pursuant to a secured claim. That's kind of true. It's true economically. But technically what 541A1 says is all legal interest of the debtor in property. D does have a legal interest in the property even if it's completely covered up by a mortgage. So you kind of want to just make sure you keep your vocabulary correct there. Okay, same is true to an extent with problem 311 with exempt property. We talked about exemptions last time. The idea is that state law will exempt or let you keep certain property from collection by creditors. Unless you've, of course, granted them a contractual interest in it. So, but how does that jive with the concept of property of the estate? Well, let's just take a look at problem 311 to put some facts on it. So it says D has filed a Chapter 7 petition. Among his other assets, D owns, free and clear of any liens, a 2008 Volkswagen Jetta, and also a gold wedding band. That's the only things he took away from his failed marriage. Jetta's worth about $2,000. Could sell the ring for about $500. Now, guess what? Here's exemption laws. In D's state, a debtor is entitled to an exemption for one car up to $6,500, and in items of jewelry each up to $750, total no more than $2,000. Short answer: both this car and this gold wedding band are exempt. Right? Now, however, what does 541A say? It says that property of the estate is comprised of all legal or equitable interests of the debtor. Does our debtor have an equitable interest in the Jetta? Yes. Does he have an equitable interest in the wedding band? Yes. So again, keep your vocabulary straight. We would say it's property of the estate, at least at first. Now, how exemptions work, and we'll talk about this a little bit later in the semester, is there are certain procedural steps where you can list and identify your claimed exemptions. And if that is upheld by the court and there's no objections to it, then and only then does the property pass from the estate back to the debtor. But certainly, as of the moment of filing the case, it is the Jetta and the gold wedding band are property of the estate. And so you'd want to make sure and keep your vocabulary straight. Yes, they are property of the estate, but of course he's able to take them out of property of the estate by filing the correct paperwork and claims to exempt them and kind of carve them back out. But you have to take those steps, so that's kind of the point here. One further note on exemptions. This is on your text, page 56, 57. First off, we're going to cover them later in the semester in a little more detail. But as the text mentions, there's several categories that we'll talk about in the code. One of them, just to mention here, besides homestead and cars and things, is any retirement funds you have, like a 401k or an IRA, are generally exempt. That's not a big surprise, but it's just by way of mentioning here. Okay, next up on page 57, we have turnover of property of the estate. So the concept here, as page 57 says, is that when bankruptcy is filed, property of the estate is property of the estate, and that's whether it's in the possession of the debtor right then or wherever located and by whomever held. And so, as I said a while ago, if you've loaned your saxophone to a friend, then even though that's true and it's down the street at your friend's house, as soon as you file bankruptcy, that is property of the estate, even though it's held by him. This is a little more of a sophisticated example of that. The problem 312 is illustrating with respect to receivership. So let's just take a look. There's a very specific code provision that we'll see that applies here. So it says debtor owns and operates this apartment building, upon which Dime Savings Bank has a mortgage. On debtor's default and the mortgage, Dime institute this thing, state foreclosure proceedings, and the state court entered an order that appointed you a receiver. So that's a thing. You're a receiver. You're like a trustee outside of bankruptcy. You're supposed to take possession of, and operate the apartments now under the receivership. Now, upon so doing, you discover extensive and gross mismanagement by the debtor in the form of general maintenance deficiencies, failure to obtain a required certificate of occupancy, failure to comply with local building ordinances, failure to obtain, in other words, they've been doing a whole lot of bad stuff. So Dime, the bank, advances you money to keep running the thing to kind of fix all these problems. But right as you're in the midst of remediating some of these problems, guess what the debtor does? Debtor files bankruptcy. Now, you were sort of in possession, you were holding as receiver the apartment building legally. Now what? Well, it tells you to see 543A. First off, 541A, remember, says filing a bankruptcy creates an estate which is comprised of all the property, wherever located, and what by whomever held. Well, you're a receiver, you're holding it. Is this property of the estate? Well, spoiler alert, yes. See next slide for section 543, which says a custodian with knowledge of the commencement of the case and its title concerning the debtor may not make any disbursements from, take any action, in the administration of what property of the debtor or proceeds, product, offsprings, rents, or profits, or property or property of the estate in the possession, custody, or control of the custodian. This receiver, you as receiver were in control of this property as custodian. That's what you were as a receiver. So you're basically supposed to freeze, and not only that, but look at 543B. A custodian shall do what? Deliver to the trustee the property. Okay, it's got a lot of details here, but that's the bottom line. Custodian shall deliver, or sometimes it's referred to as turnover, to the bankruptcy trustee the property. So the question, debtors file bankruptcy, what do? You turn it over. That's what you do. Dear trustee, here you go. I will surrender. I will stand down as custodian, as receiver under the state proceeding, because now you filed bankruptcy, and that sort of supersedes it. And that's generally the answer. Again, property estate comprised of all property owned by debtor, by whomever held. This apartment building was property of the debtor. You held it as receiver, but once bankruptcy is filed, it becomes property estate, and you got to turn it over to the bankruptcy process and quit asserting dominion over it. Now, there is a little caveat down here in 543D, which does say there's a chance you could hold on to it. It says, after notice and hearing, the bankruptcy court may excuse compliance with this section if the interest of creditors would be better served by permitting the custodian to continue in possession, custody, or control of the property. So that'd be pretty rare. It's possible that if the court decides, it'd be better for you to keep control via the receivership and not give it to the trustee, that you can keep that. How that would probably happen would be if you were pretty far into your receivership and had just about made all the steps, and it would be kind of inefficient to have the trustee start over. It may be that they say, okay, why don't you finish what you're doing? So there's some authority here in 543D to do that. But typically speaking, you turn it over and the trustee takes off from there. Again, property estate comprised of all the property by whomever held, including a trustee or a custodian. All right, so that brings up our next building block. So we've done discharge was building block number 1. Now we just finished talking about building block number 2, which is property of the estate. And so building block number 3 that we want to talk about is the concept of claims. The concept of claims. So what do we want to say about claims? First off, this starts on page 58. What is the relevance of claims in a bankruptcy? So remember, we just talked about discharge. In fact, we just finished talking about it in this podcast a little while ago. So with discharge, of course, that is eliminating debtors' personal liability on debts. Now remember that discharge applies to all debts that arose before bankruptcy. Here we find out that debt is defined as liability on a claim. And so in other words, if one has a claim, the bankruptcy discharge eliminates the debtor's personal obligation on it going forward post-bankruptcy. I.e., if it's a claim, bankruptcy gets rid of debtor's obligation on it. After the bankruptcy case or distribution, it discharges it. So it's kind of two sides of the same coin. From debtor's standpoint, it's debt, right? From debtor's standpoint, what they owe is debt, and they want to be discharged of it, right? From the creditor's standpoint, the creditor's point of view is that it's their claim, right? So they have a claim, and from debtor's perspective, they owe a debt. But from creditor's perspective, they're asserting a claim. And so debt is defined as liability on a claim. But since we know that discharge gets rid of debts, then bankruptcy discharge gets rid of claims, right? So that's good news from the debtor's perspective, but of course bad news from the creditor's perspective, who doesn't want his claim to be eliminated. So again, bottom line, now we switch to the creditor's perspective. Creditor, I'm sorry, but if what your rights that you're asserting against debtor, if they are characterizable as a claim, quote unquote, then it's gone, right? Bankruptcy eliminates at least debtor's obligation on it. So now we kind of switch gears and look at these things from the creditor's perspective and think, oh no, we represent creditors. When does bankruptcy eliminate their rights? So we start with the definition of claim under the code, section 101.5, and that's in your book on page 58, 59, although I have it right here. Claim has kind of two components. It means, first of all, right to payment, right? Right to payment, and notice this is very, 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 very broad. Completely any feasible right to payment is going to be a claim. Whether or not it's reduced to judgment, whether it's liquidated, unliquidated, that means fixed dollar amount, whether it's fixed, whether it's contingent, right, contingent on something else happening, whether it's matured, due or not, unmatured, whether it's disputed, undisputed, whether it's legal, equitable, secured or unsecured, any of those variables or characterizations nevertheless still mean a claim, right to payment. Now notice there's an or here, right to payment or subsection B, not only that, but right to an equitable remedy for breach of performance of something. As long as such breach also gives right to right of payment. And then we have a lot of the same caveats. Now if you think about breach of contract from your 1L year, this is kind of the first and foremost thing that this was referring to. If someone, breaches a contract, they owe you money, right? But think about it. If you remember from contract that you may possibly be able to get specific performance. And so that would be an equitable remedy. Although, it's kind of your option. You can also get right to payment. So that was kind of the first and foremost type of rights that were contemplated here, is the rights relating to contractual rights being right to payment for payment of money damages, that's subsection A, but then possibly right to injunctive relief, equitable remedy, such as specific performance, that's kind of subsection B. Now, as it turns out, we're not limited just to contract rights, because a couple of the cases deal with statutory rights, like rights to environmental cleanups, for instance. But certainly contract rights would be the first thing that comes to mind. But again, bottom line, either right to payment or right to an equitable remedy, as long as it's accompanied by right to payment. Now, we're going to get to that second part in a minute, but first, just kind of getting at all the various caveats: disputed, fixed, contingent, etc. You kind of want to make sure you see how broad this is. So look at problem 313. Notice we're going to focus on disputed claims. So P sues D for $100,000. D files an answer denying liability. D disputes that they owe whatever the cause of action is. D later files a bankruptcy. Does P nevertheless still have a claim? Well, yes, right? Easy. Claim means a right to payment. Now, you might say he may not have a right to it. He may lose the lawsuit. But again, right to payment whether or not it's disputed. Now, will his claim be ultimately valued at a full $100,000? No, maybe we'll decide it's valueless and it's only worth 10 cents. But it is, at the bankruptcy filing stage, a claim. He has got a claim. It may be disputed, but that does not take it out of the definition. Claim means any right to payment, whether or not it's disputed. How about contingent? Problem 314. C loans D $200,000. G guarantees payment. Now, D files for bankruptcy. Does C have a claim against D? That's easy. C's the direct creditor. Yes, right? But does G? Now, little guarantee law. What happens? G is sitting out here as a guarantor. G is saying, hey, C, if D doesn't pay, I will pay you, right? Now, what happens in the real world if C says, oh, you know what, G, I do think I want you to pay me? Does G get any claim? Yes. Remember, G has a claim back against D for contribution. The idea is, hey, D, you deadbeat, I guaranteed your debt to C, and you were supposed to pay it, and I was only supposed to pay it if you don't pay it. Well, guess what? You didn't pay it. Now I was asked to pay it. Now, guess what? I didn't just do this as a favor to you. We had an agreement. It was a guarantee. Now, it's only right under the law of guarantees that since I paid your debt, you got to pay me back. Right? You gotta reimburse me. I want my contribution back from you. Now, so eventually, G will have this claim. Now, guess what? As at the moment of bankruptcy, none of that's happened yet. But not only do we say C has a claim, we say G was, because claim means right to payment, whether or not it is what? Contingent, right? Contingent on all that happening. At the moment bankruptcy's filed, G says, well, I haven't been asked to pay yet. But you know what, darn it, one of these days, D might default and C may come after me. And if he ever does, in that case of that contingency, then I will have this claim back against D for contribution. So as of bankruptcy, what we say is that G has a contingent claim, but under the definition of 101.5, a claim includes right to payment whether or not it's contingent. So G has a contingent claim. It may not ever come to pass, but it is contingent. Now, how do we value that? We'll worry about that a bit later. But it is a claim. Now, for our purposes, at the moment, the real important thing is that claim goes away, right? It's discharged in bankruptcy. So G is going to have to get whatever they can get from D in the bankruptcy, because never again will they be able to. It's because that's the point, is that claims are eliminated. So G's, even though it's only a contingent claim, he gets whatever he gets from D's bankruptcy, and then that's the end of the story of G seeking contribution from D. Okay, so even though it's only a contingent claim, it is a claim, which means bankruptcy is going to get rid of it. Now, guess what? Same exact question. Oh, this is going to throw some of you at first. Number 2 is the same exact question. C, instead of a guarantee, it's a paint job. C gets her car painted by D, Inc., and the paint job has a 5-year, no crack, no peel warranty. 2 years after the paint job, D, Inc. files for bankruptcy. Does C have a claim? Does it matter if the paint shows no sign of cracking or peeling. Guess what? Same thing. When the bankruptcy's filed, the paint may look great. But could D-Inc. ever possibly have a claim? What if the paint starts peeling in 6 months? Well, at that point, in that contingency, they'd have a claim, right? So just like the guarantor in the previous problem would say, well, no, I haven't been demanded to pay the debt yet, but that contingency might occur. Well, same here. D-Inc. can say, well, that contingency might occur. The paint might eventually start cracking and peeling. And so at that point, I would, of course, have a direct claim for breach of warranty. And so as we stand here now, I have a claim. It's contingent. It's contingent on that breach of warranty happening, the cracking and peeling of the paint starting to happen. But until it does, it's merely contingent. Now, it's also unliquidated. We don't even know what the dollar amount would be, right? Liquidated means we know the exact amount. My claim is $3,422. So it's both unliquidated and contingent. So what's the answer? Yes, C has a claim, right? It's contingent claim, but it's a claim. And even though it's only contingent, the fact that it's a claim means, C, I'm sorry, but now that D-Inc. has filed for bankruptcy, you're going to have to get whatever you get from them in this bankruptcy, because in the future that's going to be gone. Now you may wonder, well, how do you do that when you don't even know how much it is? Well, we'll talk about that a bit later. Bankruptcies like this tend to set aside monies for a fund for future claims like that, especially in mass tort cases, which we'll see in a minute. They do that with insurance money, and they're kind of required to do it because the bankruptcy court knows, hey, there may be these claims. There are going to be some cracked paint jobs in the future. You got to do something that kind of looks like you're at least making some effort to deal with those claims. So that's kind of how it happens. We'll kind of allude to that in a little bit later. But for now, yes, D-Inc. has a claim, albeit a contingent one. That means it's a claim. That means bankruptcy gets rid of it. Okay, how about unmatured? Guess what? We're kind of illustrating the same thing. Now we look at a long-term lease. L, standing for landlord, I suppose. L leases a building to D on a 25-year lease. Okay, it says 2 years later, D files a bankruptcy petition. At the time of the bankruptcy filing, D's current. The tenant is current on its rent, and he's filed bankruptcy. Does L have a claim? Landlord's sitting here going, hey, look, there's 23 years more on this lease. Yeah, I want you to pay all those 23 years. And so what if D files for bankruptcy? Well, the answer is, again, it's not so much contingent because that contract obligation is coming, but it is unmatured. It's not due yet. It's not due for 23 years. But matured or unmatured claim means right to payment. Landlord has a right to claim, a right to payment. 23 years into the future, it's not matured yet. It'll mature month by month, year by year. But we say, as of that moment, he has a claim for the whole schmear, the whole amount. Now, again, how do we value that? We'll talk about that a little bit later. But it is a claim, and whatever landlord is going to get is going to have to be dealt with in this bankruptcy. So answer is yes, landlord has a claim. By the way, the end of the problem says, what if landlord files a bankruptcy petition? Would D have a claim? The answer would be there, yes, too, right? Whatever you have, you have. And you have to get what you get from the bankruptcy or things go away. Now, so we have right to payment. 1015 requires right to payment. This is sort of starting the material on page 59. Now we have a couple of cases that stretch this concept a bit. And the first one is Ohio v. Kovacs, and that's on page 60. And what happened here was that Kovacs was CEO of a company called Chemdyne Corporation, and they had operated a hazardous waste disposal site. And they had been sued by the state of Ohio back in 1976 for environmental law violations. And in 1979, both the corporation and Kovacs individually as CEO, they entered into a consent judgment with the state for the following. And there were three things that happened. One, there was a future injunction, like, go ye therefore and do not pollute anymore. There was a cleanup requirement. Hey, clean this current mess up right now. And then there was actually a payment $75,000 payment for, I think it was compensation for injury to wildlife. The case wasn't really about 1 or 3. I mean, 3 was clearly a claim. It was money amount, right? Number 1 was a future injunction. You cannot pollute in the future. And the case wasn't really about that, but it was about this second part, this cleanup obligation. The issue is whether or not that cleanup obligation was a claim. And the state tried to say, no, right? We're not wanting money there. We're wanting you to just go do it. Go roll up your sleeves and go clean it up. Well, the issue was, and by the way, obviously Kovacs filed bankruptcy, which is why it's a bankruptcy issue. Kovacs filed bankruptcy to kind of eliminate this. Well, before Kovacs filed bankruptcy, a critical thing was that the state had gotten a receiver to take possession of the hazardous waste disposal site. And by the way, also that receiver was ordered to seize and obtain assets of the corporation and Kovacs. And what were those assets for? To sell and get money to help with the cleanup. And that was the kicker. Kovacs said, look, you can say it's not a claim, that it was just actions cleanup, but you really wanted money. You were trying to get my stuff to sell it to get money to fund the cleanup. And the court said, yeah, Kovacs, you're right. They say on page 61 and 62, there's little doubt that the state had the right to this equitable remedy under state law, and that the right had been reduced to judgment in the form of an injunction ordering the cleanup. But the state also secured the appointment of a receiver who was ordered to take possession of all of Kovacs' non-exempt assets. What the receiver ultimately wanted was the money to defray cleanup costs. So the court said, sorry, 1015 includes equitable rights that relate to payment of money, right? And so here the equitable right was the injunctive right of cleanup, but because you also wanted money, then who are we kidding, right? That was a claim. Sorry, state of Ohio, when Kovacs filed bankruptcy, you can't get his assets anymore, because that would be a claim that relates to money. You want assets, you want money, that's a right to payment of money, and so he was able to get rid of it. Now, the court, and by the way, this went all the way to the U.S. Supreme Court, as you saw. The court was at pains to note some things, right? They said, hey, this doesn't affect whether you're going to be criminally liable. To the extent any of these were fines, those are not dischargeable. That's Section 523. We'll talk about that a little later. The future injunction obviously is not discharged. And so that, it wasn't like everything the state wanted was eliminated, but this cleanup obligation, they said, sorry, that's a claim because you ultimately were satisfied with getting money for it to help fund the cleanup. So you just want to look, ultimately, even if it's an equitable remedy, does it ultimately tie into payment of money? All right, so next up is this concept of future claims. So this is starting in your book on page 65. We got the Solitron case here. Let's just talk about Solitron, and then we'll kind of answer what's going on here. So Solitron involved, it was another environmental situation, kind of how we have a couple of these here. And in Solitron, what happened was the debtor, Solitron Devices, which ultimately filed bankruptcy, they were a company, and they apparently committed some environmental violations way back in the 90s and before. And they filed bankruptcy, in fact, way back in 1993. And like 20 years later almost, there were some other parties that were held responsible for some of the environmental pollution. And the New York State Department of Environmental Conservation, that's NYSDC, pursued those individuals for the environmental violations related to this landfill in Clarkstown, New York. And these various parties settled, but they're like, hey, we want contribution back against Solitron. It was their fault this was even a mess in the first place, so we think they're ultimately liable. Solitron said, what are you talking about? We got rid of all this when we filed bankruptcy a while back. And the other party said, what are you talking about? How could they have had a claim against you way back then? Because they didn't even know the extent of the problem in 93. So there couldn't have been a claim back then. This didn't even manifest until the future. And that winds up being the issue, as I have here on the slide. Did NYSDC have a, quote, claim against Solitron way back in the 93 bankruptcy for the environmental problems at the Clarkstown landfill site, even though those violations didn't manifest until well after that bankruptcy. The New York agency and the other parties were saying couldn't have been. You didn't know the future back then. You didn't know the extent of the damage. So how could there have been a claim you got rid of when we didn't even know? That had to have been future. It couldn't have been something you got rid of in the bankruptcy because it couldn't have been even contemplated. Well, guess what? Not so fast. The court cited from a products liability case, the Piper case, over on page 70. And there is a so-called pre-petition test, pre-petition relationship test. And what they said on page 70 is, they quote Piper, and they say, Piper held that a products liability claim does arise in bankruptcy when, number one, events occurring before confirmation, really in this case, just think before bankruptcy, create a relationship such as contact, exposure, impact, or privity between the claimant and the debtor's product. And number two, the basis for liability is the debtor's pre-petition conduct in designing, manufacturing, and selling the allegedly defective or dangerous product. Now, so in mass tort cases, Piper was a airline manufacturer case. There were aircraft that were having defects and falling out of the sky, and people were getting killed. And so Piper said, "Oh well, that happened. We didn't know that people were going to get killed or those planes were going to fail." And what the court there said, "Well, yeah, but look at Piper. You manufactured the planes 10 years before or 5 years before, and so that was enough, right? You set the thing in motion way back then before you filed bankruptcy, and even though it didn't manifest the harm till later, what you did that caused this you'd already done it and set it in motion before bankruptcy." Another thing. There's other cases like asbestos cases or breast implant cases where, hey, you made the breast implants and set it in motion. It's true they didn't get hurt or injured until far later, but because you had that contact, same with asbestos, you made the product beforehand. And then here in Solitron, they're essentially saying, Solitron, sorry, you did contact with the land. You had pre-petition activity on the land prior to your bankruptcy. Now, by the way, this is going to go bad. I actually kind of realize now that I mischaracterized who's arguing who. A while ago, I was saying that Solitron argued that couldn't have been a claim, and that New York said well, heck, now that I'm sitting here thinking about it, I don't know how I said it, but forget what I said then. Listen to what I'm saying now. It's bad for New York that this is a claim, right? Solitron is arguing pre-petition test. They're saying, hey, sorry, guys, you're wanting to come after me, but what you're coming after me for was a claim. It was a claim way back then because it's based on my pre-petition contact with this land. And I'm sorry, but this was a claim. Whatever liability I had was discharged in my 1993 bankruptcy. I had a pre-petition relationship with this land where I caused the problems. And whatever you wanted to get out of me, you should have gotten out of me in the 1993 bankruptcy. It was a claim. It was related to my pre-petition contact, and therefore it is now discharged. You cannot come back after me. And so New York and the other parties lost this case because of that pre-petition relationship test. All right, I hope that makes sense. Moving on, there's a quick note on claims estimation. Don't want to focus on it a whole lot. Page 71, 502 simply says, 502C1 says, you can actually estimate claims for purposes of allowance. What is ultimately supposed to happen is that the claims are fully adjudicated and ruled on about how many cents on the dollar you're going to get out of the estate. But sometimes you want to do a temporary estimate for various reasons. I'll tell you one way it comes up is the Chapter 11 plan voting process. We're not going to talk about that a lot this semester, but only good claims get to vote. Sometimes you haven't resolved whether you have a claim or not. It's disputed, but we'll say, all right, we'll temporarily allow your claim and estimate it for voting purposes, and then we'll come back to finally adjudicate it in the future. Another quick note on trading claims, page 72. In a word, you can do this. Problem 316 on page 73 says D files Chapter 11 petition. V, one of D's vendors, has an unsecured claim against D for $600,000 and has filed its proof of claim for that. T has offered to buy the claim for a mere $50,000. Mere $50,000. So it says, can V sell its claim? And of course, yeah, this is America. You can sell stuff like this. And so you can sell your $600,000 claim for 50 grand. And it says if V sells the claim to T, should the claim now be treated by the bankruptcy court as a $600,000 claim or $50,000 claim? Well, what'd you buy? You bought a $600,000 claim. Claim means right to payment. There was a right to payment of 600 grand. You can buy it for whatever you want. Now, by the way, remember, you're only getting cents on the dollar in bankruptcy. So what is T betting on? T is betting that he's going to profit, that the bankruptcy case is going to pay more than $50,000 on this $600,000 claim. So let's say even if they only pay 10 cents on the dollar, he's going to get 60 grand on a $600,000 claim. That'd be a nice little $10,000 profit. Perfectly fine. Happens all the time. Nothing in the bankruptcy code prevents selling your claim. And when you buy it, you get what you paid for, the right to assert the full claim, whatever that's going to yield in the bankruptcy. All right, so our final topic of this assignment in Syllabus Unit 2 is secured claims and creditors. So this is starting in your book on page 73. We kind of mentioned before when we met our first day that certain creditors have better rights than unsecured creditors. And the first and foremost way to have better rights is to have a property interest, a lien, a secured claim, so that if the debtor defaults, you can sell some stuff and use that money to pay off the debt. So there, as your book says here on 73, I think, liens fall in roughly 4 categories. So you can have consensual liens in real property. That's what we call a mortgage. If you don't pay the debt, we can sell your house and use the money to pay off the debt. You can have a consensual lien in personal property. That's called a security interest. That's governed by Article 9 of the UCC. So the idea there is, your car loan is a security interest. If you don't pay your car loan, we can repossess your car and pay off the debt. Then you can have non-consensual liens, of course. Non-consensual liens derived by judicial proceedings. That's like a judicial execution lien. So Visa sues you, gets a judgment. They get they seize interest in some assets and they can sell them to pay off the judgment. Then you can have a non-consensual lien derived by statute. That's like a tax lien or a mechanics lien. So you don't pay for some construction or some car repair services. They can, by statute, keep your car and use it and sell it. Same thing with the IRS. You don't pay your taxes. They can seize your stuff and sell it to get some money to pay off the debt, the tax debt. Okay, well, how does the bankruptcy code handle secured claims and creditors? Well, a very important provision is 506A. And this is how we kind of measure the claims of secured claims and creditors. And if you look at 506A, it does a couple of things. Spoiler alert, it bifurcates secured claims, okay? So let's take a look at what it does. An allowed claim of a creditor which is secured by a lien on property in which the estate has an interest is a secured claim to the extent of the value of such creditor's interest in the estate's interest in the property. So that's a very long-winded way of saying, hey, it's a secured claim to the extent of the value of the collateral, right? The extent of the value of the collateral. So if the car's worth 10 grand, you got a secured claim of 10 grand. But it's an unsecured claim to the extent that the value of the creditor's interest in the collateral is less than the amount of such allowed claim. Leave this alone for a minute, and let's just take, you got a creditor, the debt is $100,000, but you only got collateral worth $80,000, okay? So what would we say? You have a secured claim of $80,000, because that's the extent of the value of the property. Now, the debt is $20,000 more than that, so now you have an unsecured claim. That's like the negative equity, the part you're underwater, of $20,000, right? If the collateral was worth a full $100,000, you would have a secured claim of $100,000, and that'd be it. By the way, if the collateral was worth $120,000, you would still only have a secured claim because you don't get a claim more than the debt, right? That would just mean you would have more collateral than the debt is. But if you have less collateral than the debt is, then you get both a secured claim and an unsecured claim. Now we'll come back to that second sentence at the very end. I want to quickly get through problem 317 because I think this is pretty straightforward, and then we will take a look at that last sentence. So problem 317. D owes M $100,000. M has a first mortgage on Blackacre. Blackacre has a value of 60. What's the amount of the secured claim? Well, just like we said, it's 60, right? 60,000. By the way, not mentioned is that the unsecured would be 40. Okay, because that's the negative equity. How about number 2? D owes M $100,000. D only has a 50% ownership interest in Blackacre. M has a first mortgage on Blackacre. Blackacre has a value of 60. So you got to follow it all the way to the end. So what's the amount of M's secured claim? Now, M only has the mortgage. We only know that D is the borrower, right? So M probably only has the mortgage interest in D's 50% ownership. 50% ownership of 30 is what? Or of 60 is what? It's 30. So the secured claim would be 30, right? Which means the unsecured would be 70, right? Because the full debt is $100,000. Okay? So that's number 2. Well, to go back, again, we only take the 50% because you only say the secured claim is the extent of the value of the creditor's interest in the estate's interest, right? The estate only had a 50% interest, so we're limited accordingly. How about number 3? Now we add another variation. Once again, the debt is 100. D owns Blackacre in full this time. Now we have 2 liens. M has a second mortgage on Blackacre, but F has a first for 20. Blackacre's only worth 60. So you got property worth 60. We have this F first mortgage of 20. What's left? There's only 40 left for M. Okay. So M's secured claim is 40. Right? Now that means, of course, the unsecured claim is 60. M only can have what's left over after the first lien position of F of 20 is accounted for. That means M has $40,000 unsecured claim because they have a second mortgage, second in priority. Okay, so that's number 3. What about number 4? D, we start off with $100,000 in debt. M has a mortgage on Blackacre. D files for bankruptcy. M obtains relief from stay. We're going to talk about that concept a little bit later. Forecloses on Blackacre. M sells Blackacre for $40,000. Does M still have a secured claim? Answer's no, right? We liquidated the collateral. So the collateral's gone, right? There was a $40,000 secured claim there, but we realized on it. We repossessed Blackacre, we sold it, and we realized on the secured claim. We sold it, got $40,000. And applied it to the debt. Now, when we applied the $40,000 to the debt, what's left? A $60,000 unsecured claim. That's all that's left, right? And so no more secured claim at all once the collateral is realized on, but we do still have a $60,000 secured claim. Okay, last part of number 317, review question. In the above problems, is Blackacre property the estate? I would say yes. Sometimes the authors are a little confusing on this. It is, but of course it's subject to the liens. So we just have the economic reality that yes, we do have property estate, but the value of it is subject to the lien. So we just have to kind of get those semantics right. Okay, so the final thing we want to talk about is determination of the value of such creditors' interest, and this is in the book on page 70, starting on 75. So this is where we're going to get into that second sentence that I sort of put aside earlier. So remember, we already know 506A has our bifurcation. First, the secured claim is the extent of the collateral, and then if there's a debt over and above the secured amount, that's the unsecured claim. But then that second sentence talks a little bit about how do you value the collateral for the secured claim. And what it says is, such value shall be determined in light of the purpose of the valuation and the proposed disposition or use of the property, and in conjunction with any hearing on such disposition or use or on a plan affecting such creditor's interests. So a little bit about what's going on. You have the United States Supreme Court case, Associates Commercial Court versus Rash, on page 77. And what they tried to do was they tried to put some legislative meaning behind this purpose language, right? And they said, well, what are the various purposes? Well, there's basically two. There's kind of the surrender purpose, and then there's the retention purpose, right? So they said surrender, as in surrendering collateral immediately to secured party. That's when there's what we'll see called a motion to lift automatic stay. That means I'm wanting the stuff right now. That means foreclosure sale, right? No time. We're immediately doing a fire sale of this stuff, and we're going to sell it within 30 days. Sheriff's going to sell it. Boom, boom, boom. You don't really market it or anything like that. It's just quick, dirty, fast sale. That's surrender. As opposed to, they said, retention and use is not surrendering it, but that's when you want to keep the collateral for reorganization purposes, as in a Chapter 11 or 13 plan. And they said that means replacement value. Now, replacement value is generally going to be higher. Why? Because the idea of the replacement value is, hey, it's not this rushed foreclosure sale. You're going to take your time. You're going to do marketing. There's going to be time to sort of adequately market the property and all the various venues, and you'll be able to realize the greatest possible amount of money for it. And so basically, surrender value tends to be foreclosure value lower, and retention and use tends to mean replacement value or higher. So what they kind of said at this point of Associates Commercial Court versus Rash is, hey, if you're just looking at the creditors just looking to seize the property, that's when you move for relief from the automatic stay, then we can use a lower value. Whatever the facts say they are, by the way, you have to have expert testimony. But if they're going to keep it, but they're wanting to value it for purposes of a Chapter 13 plan, then we can kind of use the higher value, non-rushed, plenty of time to market value. Now, one little wrench that they threw into the works was this footnote 6 in the case, where they said, now, by the way, replacement value could mean different things depending on the context. It could mean retail. It could mean wholesale. We don't decide that question today. Well, that kind of caused everyone to scratch their head. What Congress did in 2005, after the Rash case, is they said, well, look, in certain instances, we're going to make it statutory and clear. If the debtor's an individual, a human, it's a 7 or 13 case, and we're talking about personal property like a car, then it's easy. We're going to use replacement value. In fact, it's going to be the price a retail merchant will charge. We're not going to have this goofy footnote 6 ambiguity here of retail, wholesale, or something different. It means a retail merchant, what they charge. You go to a car lot, you buy the thing, or you go to a store. And so that's kind of where things are as of the current law. Now, to see how this works, just real quickly, problem 318, and we'll be done. This is on page 78. So this is kind of, you still use Rash, by the way. You only get to use 506A2 when you have the facts, an individual, and it's personal property, and it's a 7 or 13. If it's a business, or if it's a Chapter 11, or if it's, real property, then, of course, you still have to use Rash. And so you have a problem like 318, Rash is still the law. So you have D furniture stores in Chapter 11. S Bank, S, has a first lien security interest on D's inventory. It says D owes S $1.2 million. D's Chapter 11 plan provides what? For D to continue operating as a furniture store in the same building. They are retaining. Okay. How should the court determine the amount of S's claim? You want to say we're retaining. We want that higher value. Now, the problem told you to look at Justice Easterbrook's concurring opinion in this Sampson v. Alton case, In re Ebler Furniture. But first things first, retention, we'd want to use replacement value. That's the higher value, so not the lower foreclosure value. What would an expert say it's worth? Now, what Ebler said, at least Easterbrook's opinion, was, hey, well, speaking of that Rash footnote 6 problem, he thinks in this particular case, he said, I don't think it should include basic overhead, like amounts attributable to the normal retail price of wages, rent, utilities, etc., bad debts. So he wanted to argue for a lower amount. And the opinions sort of suggested that, well, for purposes of this valuation, bank doesn't have a security interest in all these other overhead items. They could just seize the property and sell it. Query whether or not other courts would agree, because that kind of looks almost like foreclosure value. So I don't know how much I would put stock in this Ebler case, but in general, the concept is RASH stands for the proposition that it should be higher than foreclosure value, surrender value. It should be replacement value, even if we quibble with what amount should go into that determination. Okay, so we were going to skip the Deswnup case and then those problems 319 and 20. So that is the end of the podcast. Thanks for listening to this. Please be sure that you do, although if you're hearing my voice now, you have listened to it because you're at the end. I appreciate you letting me make up the class this way, and then I will be posting this and, of course, giving you more information for our class on Wednesday. By the time you've listened to this, I've probably already done so, but make sure you look for that anyway. See you guys in class on Wednesday.